I indicated this is the first subcommittee that I've chaired in 8 years in Congress, and I was nervous, apparently nervous enough not to turn on the microphone. So we look forward to being educated and getting a good understanding. First, I want to thank my colleagues and their level of interest in this important topic. I'd also like to thank, as I said, our witnesses for joining us today. Expertise is important to us as members of Congress, and unfortunately, this is a very timely topic. The purpose of this hearing is, in many ways, somewhat narrow. It's to examine the merits of the federal data security standard and the need for preemptive and uniform federal data breach notification. We all know we live in a digital world where consumers have embraced online products and services. Kansans, my folks at home, they know they can make purchases, determine their credit score, conduct banking, and examine health care plans, all from a mobile phone, computer, or a tablet. That is true of consumers across the country and increasingly around the globe. But this digital economy creates new risks. In a world where one bad actor can battle against a team of highly trained experts, we face challenges to make certain that consumers are protected and that businesses have the tools and incentives to protect their customers from harm. For more than a decade, Congress, the Commerce Committee in particular, has been contemplating issues surrounding data security and data breach notification. In 2004, the committee held its first congressional hearing to examine the high-profile breach of ChoicePoint, a data aggregation firm. This breach forced the first of many conversations here in Congress, and today we continue that dialogue. Recent high-profile data breaches, as well as the headline-grabbing Sony cyber attack from late last year, are the latest examples that highlight the ongoing and serious cyber threats that face Americans and businesses. And just this morning, we woke up to news of what experts are calling the largest healthcare breach to date. This time, the cyber criminals were able to infiltrate the nation's second largest health insurer to steal names, birth dates, medical IDs, social security numbers, street addresses, email addresses, and employment information, including income data. These high-profile breaches are the most severe of what has become a common occurrence in our digital society. As of 2015, the Privacy Rights Clearinghouse has estimated more than 4,400 breaches involving more than 932 million records that have been made public since 2005. The Verizon 2014 data breach investigation report reviewed more than 63,000 security incidents and found 1,367 confirmed data breaches in 2013. So on average, that's just shy of 4 breaches every day. While Congress has developed sector-specific data security requirements for both financial institutions and companies that handle particular types of health information, Congress has been unable to reach consensus on the development of a national data security and data breach notification standards. As a result, states have taken on this task by developing their own standards, and as of today, businesses are subjected to a patchwork of over 50 different state, district, territory laws that determine how businesses must notify consumers in the event of a breach. In addition, 12 states have enacted laws regarding data security practices. The need for federal action becomes clearer each day. Last month, President Obama voiced his support for national data breach notification legislation with strong preemptive language, in part because he recognizes the benefits to American consumers and businesses of a predictable, uniform data breach notice. The President's support, along with bipartisan and bicameral congressional interest, has renewed optimism among stakeholders that Congress can develop a balanced and thoughtful approach with legislation in the near term. Today, we'll focus our attention on some of the key questions and topics of this debate, including what are the benefits of a national data breach notification standard? Should Congress implement a basic data security standard? To whom should that standard apply? Should the federal standard preempt state standards? What should be the trigger for notification, the specific conditions that represent a potential harm to consumers? Should there be exemptions and safe harbors? If so, for who? In what circumstances? Within what time frame should a company be required to notify consumers? Should Congress enact new or stronger penalties for enforcement authorities and remedies? What lessons can we learn from states that have implemented their own data breach notification standards? I'm confident that our panel, its expertise, can share valuable insight into those questions and others that the committee members may have. as we work and help us find a right balance to these issues. I'd like to recognize the subcommittee's ranking member, Senator Blumenthal, for him to deliver his opening statement, and I would indicate to Senator Blumenthal here in public, as we have in private, that I look forward to working very closely with you in a very thoughtful and bipartisan way to see that our subcommittee accomplishes good things for the country.
Thank you.